Jefferson County Court at Law number 2 is back in session with the arraignment docket. First two cases are cause number 23CCCR0433 and cause number 23CCCR0430. Case is styled the state of Texas versus Andrew Chase Hoosier. Mr. Hoosier, would you please come forward? Mr. Hoosier, your full name is Andrew Chase Hoosier. How you doing, Mr. Hoosier? That's good, Mr. Hoosier. Would you please raise your right hand? Mr. Hoosier, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Hoosier, you may put your hand down. Mr. Hoosier, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line stating that you want to have your case reset so that you have your case reset to hire your own attorney?
Yes, sir.
Okay. Now, Mr. Hoosier, before you signed and initial this document, did you read the document?
Yes.
Did you understand what you read?
Yes.
And is everything in this document true and correct to the best of your knowledge?
Yes.
Okay. Mr. Hoosier, I have before me another document here. Mr. Bailiff, would you please hand this document to Mr. Hoosier? Mr. Hoosier, the bailiff was handing you a document that is titled Standard Bond Conditions in County Court at Law number 2. Do you see that title?
Yes.
Okay, I'm going to go over this document with you, and it reads, following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of defendant in any. Let me read this again. Following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submits to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes.
And condition number 4 does not apply because that only applies in a DWI case. Now, condition number 5 does apply. Condition number 5 states the defendant shall wear a global positioning monitoring system, which is a GPS system device, at the defendant's expense with written verification being submitted to the court within 3 days. Do you understand that condition?
And this is for, what is that condition for?
This is a condition of your bond. You're out on bond, and this is one of the conditions of your bond.
Well, vehicles, I don't have a vehicle right now.
This is a GPS. It's an ankle monitor. It's not an analog. Okay? And so you can provide verification to the court within 3 days by bringing the receipt to the court. If the court is not in session at the time, you go through the blue doors next to the court. There's a lady that will be sitting behind the glass window. She can call our court, and we'll have someone to go out and get it, and we'll place it in the file showing that you have proof of the GPS. Do you understand that?
So I have to get an ankle monitor?
Yes. Now, your case is going to be reset. Once your case is reset today, you'll be free to go and you have a blessed day. Okay? Our court coordinator is going to reset your case. Please stand, have a seat in that first chair by the wall, and she'll call you up to her window. Right there. Here you go. Daria or Dalia Douglas. How you pronounce your first name?
Dalia.
Dalia?
Yes, sir.
Okay. Miss Douglas, this is cause number 23CCCR 0552. Ms. Douglas, would you please raise your right hand? Ms. Douglas, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Douglas, you may put your hand down. Ms. Douglas, how are you doing?
Good.
I'm doing fine. Thanks for asking. Ms. Douglas, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on line stating that you want your case reset to hire your own attorney?
Yes, sir.
Now, Ms. Douglas, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Ms. Douglas, I also have some bond conditions for you. Ms. Douglas. Ms. Douglas, the bailiff just handed you a document that is titled Standard Bond Conditions in County Code at Law Number 2. Do you see that title?
Yes, sir.
I'm going to go over this document with you, and it reads, following the arrest and or accusation in County Code at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number one, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Okay. Now, condition number two, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number three, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Okay. Now, Ms. Douglas, if you violate any one of these bond conditions, sir, that door is locked. You gotta go through the other door. Now, if you violate any one of these bond conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest and you'll be placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Okay, now you're gonna have a seat in that first chair by the wall, and our court coordinator is going to reset your case. Once your case is reset, then you'll be free to go and you have a blessed day.
Thank you.
Welcome. Next case is cause number M332038, case of Style State of Texas versus Marcus Cormier. Now, how do you pronounce your last name?
It's Cajun, so.
Cormier?
Cormier.
Okay, I think Louisiana usually pronounce it Cormier.
Yes, sir.
All right. Now, Mr. Cormier, would you please raise your right hand? Mr. Cormier, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Cormier, you may put your hand down. How are you doing, Mr. Cormier?
Good. How about you?
I'm doing fine. Thanks for asking. Mr. Cormier, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on line stating you'd like to apply for court-appointed attorney?
Yes, sir.
Now, before you sign any, also, I have another document here that's titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Cormier, before you signed and initialed these documents, did you read the documents?
Yes, I did.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Cormier, I read your answers in these documents. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Mark Faggart. Attorney Faggart will be given information about how to contact you, and you will also be given information about how to contact Mr. Faggart. Our court coordinator is going to give you that information. Once you get the information from our court coordinator, you'll be free to go, and you have a blessed day. Please have a seat at that first chair, in the first chair by the wall. Next case is cause number 23. Excuse me, cause number M333458, case of style of state of Texas versus Anthony Foster or Anthony Craig Foster Jr. Please come forward. Mr. Foster, your full name is Anthony Craig Foster Jr.
Yes, sir.
Mr. Foster, would you please raise your right hand? Mr. Foster, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Foster, you may put your hand down. How are you doing, Mr. Foster? Oh, I'm doing fine. Thanks for asking. Mr. Foster, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you want to waive your right to an attorney to represent yourself?
Yes, sir.
I also have another document here that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding a Trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that is titled Defendant? Now, Mr. Foster, before you signed and initialed these documents that I just mentioned to you, did you read the documents?
Yes, sir. Understood.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, so now, Mr. Foster, just please have a seat. And in a few minutes, we'll have a prosecutor come out and talk to you. Next case is cause number 23CCCR0568. Case is style the state of Texas versus Eric Von Benjamin. Mr. Benjamin, your full name is Eric Von Benjamin?
Yes.
Mr. Benjamin, please raise your right hand. Mr. Benjamin, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Benjamin, you may put your hand down. How you doing, Mr. Benjamin?
Yes, sir, Judge.
You're doing fine. That's good. Now, Mr. Benjamin, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line stating you want to waive your right to attorney to represent yourselves? Also, I have another document here. This other document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding the Trial. Do you recognize this document? You do? And is this your signature on the line that's titled Defendant?
Yes.
Now, Mr. Benjamin, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Benjamin, just have a seat. And when our prosecutor is ready, the prosecutor come out and talk to you. All right. Next case is cause number M328532, case of Style of State of Texas versus Antonio Luis Reagan. Mr. Reagan, would you please come forward? Mr. Reagan, your full name is Antonio Luis Reagan.
Yes,
Mr. Reagan, would you please raise your right hand? Mr. Reagan, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth shall be God? Mr. Reagan, you may put your hand down. How you doing, Mr. Reagan? I'm doing fine. Thanks for asking, Mr. Reagan. I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
yes, sir.
And is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line stating you would like to apply for court-appointed attorney?
Yes.
I also have a document before me that is titled Jefferson County Affidavit of Images. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there is a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Reagan, before you signed and initialed all of these documents that I just showed you, did you read the documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Now, Mr. Reagan, I read your answers in these documents. Based on your answers, you do not meet the eligibility requirements for the appointment of a court-appointed attorney. And the reason why I was just looking at your income and then your bills, and let me do this here, since we're going to get into maybe some financial information of yours, pursuant to Article 1.24 of the Texas Code of Criminal Procedure, all proceedings and trials should be public. However, pursuant to the case of Lilly versus State, which is 365 Southwest 3rd, 321, the right to a public trial is not absolute and may be outweighed by other competing interests, such as security, or it could be the disclosure of non-public information like what I'm getting ready to go into. And you have a right not to have your financial information broadcast to the public. And so if you would like us, I can close this session to the public, that is, take it off YouTube and ask the individuals who are here in court to step out, and then we could discuss your financial information. Would you like us to do that?
You can do that.
Okay, so the court finds that the defendant has advanced an overriding interest that is likely to be prejudiced to him, in that the disclosure of it would cause the publication of non-public information. Also, the court finds that the closure is no broader than necessary to protect his rights. The court has also considered other alternatives to closing this hearing, and the court made the finding that the closure is necessary and adequate under these circumstances. Therefore, this hearing will be closed to the public.